Good morning, everyone, and welcome to this meeting of the BCP Licensing Sub-Committee. The first item on this morning's agenda is election of chair. I seek nominations for the position of chair for this meeting. Members?
May I nominate you, Councillor Fleck?
Thank you, Councillor Williams. Thank you, Councillor Canavan. Can I ask the clerk just to run through the housekeeping measures, please?
Thank you. Please note this meeting is being recorded by the Council for live broadcast and will be published on the website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, although ultimate discretion in this matter lies with the Chair in case of disruption. For those in the room, please note if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building in Bourne Avenue. Finally, please ensure background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. For those in the room, this includes turning off microphones and turning the volume down completely on your laptops. Thank you.
Thank you. Item 2 on this morning's agenda, apologies for absence. I understand there are no apologies for this meeting. Item 3, declaration of interest. I will ask each subcommittee member in turn if they have any declarations of interest with regard to the agenda items this morning. Councillor Williams.
I have none, thank you.
Thank you. And Councillor Canavan.
Yeah, I have none, Chair, thank you.
Thank you, members. Item 4, protocol for public speaking at hearings. A protocol for public speaking at meetings of the Licensing Subcommittee is included with the agenda sheet for noting. Item 5, application for Cristallo, 3 Westcliff Road, Bournemouth, BH2 5ES. I will now ask each participant to introduce themselves and state their role. I'm Councillor David Flagg, elected chairman for this morning's subcommittee.
I'm Councillor Patrick Canavan, member of the Licensing Subcommittee.
I'm Councillor Lawrence Williams, also a member of the committee.
Thank you, members. BCP Council, please.
Andy McDermott, legal advisor.
Jill Hollyoak, clerk to the subcommittee.
Sarah Rogers, Principal Licensing Officer, BCP.
Thank you. And persons applying for the review, please.
I'm Russell Angel with Home Office Immigration Enforcement.
Thank you. And representing the premises, please.
Brendan Herbert, Lacey Solicitors, representing the respondent.
Thank you. And
Zubair Dastagir, the licensee at 3 Westcliff Road.
before I run through the procedure, can I check that all persons who have given notice of their intention to speak have been identified, and any person who wishes to withdraw a representation or wishes not to speak has been identified. If there are no comments, I will take this as correct. I will now explain the proposed procedure and order of speaking for the hearing as follows. The licensing officer presents the report. Questions of the licensing officer by all parties, members of the subcommittee to go first. The applicant will make their application. Questions of the applicant by all parties, members of the subcommittee to go first. Persons representing the premises will make their representations. Questions of the premises by all parties, members of the subcommittee to go first. All parties will be given an opportunity to sum up, with the party who spoke last to go first. The hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and clerk present. Notification of the subcommittee's decision will be given within the period of 5 working days, beginning with the day or the last day on which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement on the proposed procedure or make representations. Sarah Rogers.
Yes, thank you.
Thank you. Andy McDermott.
Agreed.
Brendan Angel,
Brendan Herbert, but yes, agreed.
sorry. I've got a change of, and, sorry. Russell Angel.
Yeah,
Beg
that's
pardon.
me. Yes, agreed.
And Mr. Dastigo.
Agreed.
Thank you very much. Please may I remind all parties speaking not to repeat the information which they have already given in writing, but to expand on their written representations. All questions are to be asked through the chair, and there will be no cross-examination of parties. I will now ask the licensing officer to present the report.
Thank you. An application has been submitted by Home Office Immigration Enforcement to review the premises licence under Section 51 of the Licensing Act. The premises are located within Westbourne and Westcliff ward of BCP Council in a mixed use area comprising hotels and residential properties near the BIC. The review follows a visit by Immigration Enforcement on the 3rd of November 2024, prompted by intelligence suggesting the employment of illegal workers by the business owner. Under the Licensing Act 2003, the Home Office, on behalf of the Secretary of State, are authorised to enter licensed premises where there is a reasonable suspicion of offences under Immigration Acts in connection with licensable activities. The Home Office is also a designated responsible authority under the Act. No representations have been received in support of the application from any of the other responsible authorities or any other person. Ahead of this morning's hearing, I reviewed the premises history, and it revealed that the annual licence fee, which was due on the 31st of July 25, remains unpaid. As a result, the licence is currently suspended, with formal notice issued to the premises on the 8th of August. The suspension will remain in effect until the outstanding fee is paid. Members are reminded that any decision must be appropriate and proportionate, aimed at promoting the licensing objectives and specifically addressing the concerns raised in the application, once these have been identified during the hearing. Thank you.
Thank you, Sarah. Do members have any questions for the officer at all? Thank you, members. Can I call on Russell Angel to address the committee, please? Thank you.
Yes, thank you, Chair. Firstly, I'd like to confirm that all the committee members have had time to read the submission pack. Yeah, thank you. I don't propose to read through the full pack, but I'll make a few key points before I summarise the case. The ability to work illegally is a key driver of illegal migration. It encourages people to break the UK's immigration laws and provides the practical means for migrants to remain in the UK unlawfully. It encourages people to take risks in trying to enter the UK illegally by putting their lives in the hands of unscrupulous people smugglers and leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules, undercutting legitimate businesses that are. It also negatively impacts on the wages of lawful workers and can be linked to other labour market abuse, such as tax evasion, breach of the national minimum wage, and exploitative working conditions. Working illegally is a criminal offence, and on conviction in England and Wales, an illegal worker may receive a custodial sentence of up to 6 months and an unlimited fine. Employing illegal workers undermines the licensing objectives, in particular the prevention of crime and disorder. Immigration enforcement do not just drive around looking for businesses to target. We're intelligence-led, and there need to be significant concerns for us to action incoming intelligence. And we do not routinely refer to seeker licence review, but we do so in cases where we have heightened concerns. In this case, on the 3rd of November 2024, the South Central Immigration Compliance and Enforcement, or ICE team as they're known, visited Cristallo, 3 Westcliff Road, Bournemouth, BH2 5ES, after intelligence was received that the business owner was employing illegal workers. 2 workers encountered did not hold the right to work in the UK. Full details of those encounters and the events of the visit can be found in the review application submitted. Home Office guidance, which can be found on the gov.uk website, clearly states that right to work checks should be completed for all prospective employees. That's on a document called Right to Work Checks, an Employer's Guide, and that's in section 3. Should this guidance have been followed, the licence holder could have prevented illegal working at the premises. The Home Office also provides a free right to work checking system via the gov.uk website, as well as guidance and advice for and covering those whose status isn't checkable online. Using this service would have highlighted that both workers did not hold the relevant right to work. It's also concerning that both workers confirmed they were not paid in return for their work, with one worker admitting to working in return for food, an example of a vulnerable person and the exploitative working conditions I mentioned earlier. The licence holder was also found to be in breach of a condition on the licence, as no refusal log was being maintained at the time. As a result of the visit on the 3rd of November 2024, a civil penalty for £80,000 was issued to Surah Limited on the 9th of January 2025. So the penalty was issued on the 9th of January 2025. The business objected to this and the civil penalty was reduced to £40,000. Surah Limited lodged an appeal against the penalty, which is ongoing, and the civil penalty remains unpaid at this time. Licensing Act Section 182 guidance at point 11.27 outlines certain criminal activity that may arise in connection with licensed premises, which should be treated particularly seriously. This includes employing a person who is disqualified from work by reason of their immigration status in the UK. Point 11.28 states that where a review arises from such activity and the licensing authority determines that the crime prevention objective is being undermined through the premises being used for further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. In this premises, illegal working has been evidenced, along with a breach of licence conditions, as no refusal log was kept. We have no confidence that imposing further licensing conditions, changing the DPS or suspending the licence would remedy the situation. Therefore, we submit that a revocation of the licence is considered. That being said, we recognise our role is to bring our concerns to your attention as the local licensing authority. This is your area and you represent the interest of the local people. So unless I can answer any specific questions, I don't propose to take any more of your time, and thank you for your attention.
Thank you, Russell. Before I move on, I omitted to give you the opportunity to ask the officer if you had any questions, both you and Brendan. So did you have any questions at all for the officer?
No questions from me.
Thank you.
Likewise, no questions.
Thank you. Right, members, we've heard from the applicant. Do you have any questions for the applicant at all?
Yes, please.
Councillor Williams.
Try and keep my voice going. What's the status at the moment of any criminal proceedings?
There are no criminal proceedings. It's a civil penalty that is being pursued by the Home Office. No criminal proceedings against either the licence holder or either of the two workers encountered.
Thank you.
Thank you. Councillor Canavan, do you have any? No. No. Thank you. Any questions for Russell Angel at all at this point?
I don't think so. I think after I've made my submissions, then we may be able to explore everything further. But I think nothing from me at this stage.
Okay, thank you for that. In which case, then, can I ask you to address the subcommittee, please?
Good morning, everyone. As we've heard, this application is brought by the Home Office. Sorry, before I get into full flow, I should say, due to our instruction somewhat late in the day, I haven't had the opportunity to send a written submission for the committee to read in advance. So I'm going to rattle through that. If you would like a copy to assist you with your deliberations as an aid memoir, I will send it through after the hearing. But the lack of written submissions was just a function of time. With that, I will crack on. So the application is brought by the Home Office and concerns allegation that the premises employed illegal workers. These facts are disputed. It is of note that this application has only been brought 9 months after the incident complained of, and members are reminded that in making their decision, they should take into account the circumstances as they stand at the time of the hearing. By way of background, the respondent, Mr. Zabir Dagestir, who is the director of the company which holds the licence, has been at Cristallo Restaurant since around 2010. He took on a managerial role and part ownership of the premises some 3 years after starting there and was named DPS in 2021 following the death of the previous owner. The premises has until now had no issues that have required the intervention from the licensing team or any responsible authorities. It is a model establishment. Pick up on Sarah's point of the non-payments for the 2025 fee. Mr. Dastigier has tried to contact the payment line, but the payment line wasn't working. So he is aware of that, and efforts are ongoing to make sure the payment is made. Whilst the application primarily relates to alleged immigration offences, the supporting documentation also refers to alleged breaches of the conditions of the licence, specifically in relation to the requirement to keep a refusal register, which should be made available for inspection by an authorised officer on request. Whilst it's unclear to us why an immigration officer would need to see a refusal register, we do recognise that this responsibility exists and accept that it has not actually been met. The premises in question is a restaurant which will only refuse service of alcohol on a very limited number of times a year. And therefore, this condition has not remained at the front of the respondent's mind since the licence was issued some 3 years ago. Following the application, steps have now been taken to ensure that a compliant refusals register is kept and is immediately available for inspection at the premises by any responsible authority, and so as to ensure that any similar oversights do not occur again, and training records have also been put in place to ensure that they are quickly demonstrable to anyone who seeks to clarify them. As has been confirmed in the opening submissions by the applicant, no issues are engaged or arising in relation to public nuisance, public safety, the protection of children from harm, and the only licensing objective which is engaged is the prevention of crime and disorder. Even then, there is no suggestion of disorder associated with the premises, nor, it come to that, as we've heard, any crime other than the allegation of employing illegal workers. It is noticeable that the police, as a responsible authority, are not here today, and the committee will be aware that on matters of crime and disorder, they should be primarily guided by the police. As we've heard, this application surrounds the employment, and that's a very specific legal phrase which has certain meanings, of illegal workers. Now, it's not the role of the committee to determine whether the respondents technically employed a person who had no right to work within the committee. That is something that will be determined by the court in the ongoing proceedings that Mr. Dastigier has initiated. And I must say, it is disappointing on our behalf that the Home Office would not consent to a short delay of this hearing while the outcome of the civil proceedings, which is due in just 2 or 3 weeks, could be determined, because that would have led to a lot greater clarity on the underlying issues as to whether people have been employed. However, the committee does have before them the details submitted by the Home Office in respect of Mr. Jakushev and Mr. Mumzai, and we would like to make the following notes in relation to their alleged employment. Mr. Jakushev is a friend of Mr. Dastigier, who has known him since childhood. Mr. Jakushev's father works at the premises.
Excuse me, I'm very sorry, Chair. We are starting to name individuals, and there is personal information in the papers which can then be correlated to those individuals. So at the moment, this is a public hearing. So I think we need to take some advice as to whether we need to go below the line. Would you like me just to adjourn briefly while we
can I
discuss that?
Let me see if I can just deal with it. Okay. Are you able to address those
I can not
as A or B?
I can anonymise to individual A or individual B. Apologies.
I think that would make life a lot easier.
Yep, that's no problem at all.
Thank you very much, Chair. Thank you.
Thank you, Jill.
So in respect of individual one, Individual 1 is a friend of Mr. Dastier, who's known him since childhood. Individual 1's father works at the premises, and his presence there at the time of the raid were entirely social. Individual 1 occasionally helps with clearing away tables, but this is not an employment relationship. It is the act of a friend present at the premises, simply lending a helping hand from time to time. As we understand matters, the Home Office fine as it relates to Individual 1 has been withdrawn. Individual 2 was not an employee either. He had initially met with Mr. Dastier at the local mosque, and his presence was solely due to Mr. Dastier offering him some training as Individual 2 wished to become a chef. This was an entirely informal and altruistic agreement. Without going into the details of what constitutes an employee or a worker under employment law, there is a certain thresholds which must be met, the main ones of which are receiving remuneration and being subject to the control of the employer. These are not met in this instance due to the informality of the relationships and the simple fact that there was no intention to employ these people. The committee should also consider the economics of this case. There is simply no need for additional staff to be taken on by the respondent. There are four full-time staff, or there were at the time of the operation, and at that time of year when times are quiet, there are often more staff available and present in the premises than there are customers. To bring on the risks of which the respondent is aware to employ illegal workers is simply not necessary. It is also worth pointing out that until the issue is determined, Mr. Dastier has not been convicted of committing a crime. He has fully cooperated with the Home Office investigation to the best of his ability, including offering CCTV footage to support his position in the investigation, although this footage was never requested or collected. The issue is simply what steps would now be appropriate for the licensing authority to be satisfied that the licensing objectives are being upheld. It is deeply concerning that the Home Office seeks the revocation of this licence, not due to any desire to ensure that the objectives under the Act are upheld, but to deter the licence holder and other premises licences holders employing illegal workers and facilitating disqualified migrants to work illegally. This is not the role of the committee, and it never should be, and it is not the role of the Licensing Act. The committee's focus should be considering whether the premises in question can be operated in a way which upholds the licensing objectives. As things stand, the respondent faces a fine of £40,000 pending the outcome of the court proceedings. He is now fully compliant with the terms of the licence and has incurred significant legal fees in defending its position. Despite what might be said by the Home Office regarding the viability of the business, if the licence were to be revoked, the reality is that the business would lose a substantial amount of funds and likely close. I would respectfully submit that would be unreasonable and disproportionate to either revoke the licence itself or to remove Mr. Dastier as the DPS. We are happy to offer a further condition to the licence which stipulates that any individual who is at the restaurant carrying out any form of assistance, whether from a form of social relation to the individuals, for any form of social relationship or for the individual's personal development or indeed employment, must have their right to work information processed before any assistance is permitted. The respondent is aware of that requirement and responsibility and took the active decision not to do the checks in the circumstances because he was so satisfied that he was not entering an employment relationship. The respondent has a proven track record of upholding the licensing objectives, and this circumstance has alerted him to oversights in administrative operations, such as maintaining the refusal register and staff training records, all of which has now been rectified. The respondent is willing to accept an additional condition onto his licence in relating to obtaining the right to work information for any individual who will assist at the premises, and we therefore invite the committee to allow the continuation of the licence with the above condition. Thank you.
Thank you for that. Any questions at all for Mr. Herbert or members? Thank you. Any questions at all? No. Thank you. Can I just ask Sarah, can you just confirm the dates of the renewal licence and when Mr. Dastigier was notified of
So, the annual fee was due on the 31st of July 25. We send out renewal reminders the month before. If it's not paid, we then send a notice that the licence will be suspended. I think that's 2 days before, and then if it's still not paid, they get the suspension notice, and that was sent on the 8th of August. And it does have details of how to pay online there as well.
Okay, thank you. Question, Mr. Herbert. Can you confirm, or do you accept that that the employee 1 and 2 were instructed by Mr. Daskidir in the operation of the business, and that they were receiving food as an alternative to paid wages?
No, we don't accept that. I can expand if you would like.
If you would, please, for the benefit of the committee.
So, food was not offered as an alternative to wages. In respect of individual 2, who was merely being offered the opportunity to experience and see how a commercial kitchen worked, so that when his immigration status is determined later on, he will then be in a position to put himself in a better position in the jobs market. They had met months earlier, but the respondent felt that to give him sufficient time to supervise and give the necessary training or experience, I should say, it was better left in the quieter autumn and winter months. But because the individual 2 is not a trained chef, it would be inappropriate for any food he prepared to be provided to paying customers within the restaurant. So individual 2 was simply allowed to take home the food that he had been involved in the preparation of. It wasn't by way of remuneration. It was simply food that would have been put in the bin otherwise. And in these times of all, food should be used. And with individual 1, as I say, his presence is solely social, so there was no relationship of instructing. And forgive me, I don't know if there's any suggestion that he was provided food, but if he was, it certainly wasn't by way of payment for services rendered.
Okay, thank you for that. Members have any questions on the balance of that at all?
Questions arising from what the respondent said in terms of the Home Office. Can we ask those?
Can I ask the same question to you, Russell? Obviously, we aren't able to cross-examine parties, but I'm asking the same question to you because obviously your report basically highlights that.
Yeah, absolutely. So yeah, our officers spoke to both members of staff on the day using an interpreter where relevant, and the individual number 2 in particular said that he worked at the premises for 2 days. His job was to wash dishes, so it's different to what's being said there. And he was not paid and received free food in return for his work, was the comment that was made. All that is available in the review pack. I don't have anything to add on top of what's in that pack, I'm afraid. I wasn't there at the time, unfortunately.
Okay, thank you for that. Happy with that, councillor?
It's been suggested on the basis of what's just been presented to us that the Home Office have withdrawn their objection to individual one. Can you confirm that's the case?
Yes, I can confirm that there is a civil penalty proceeding in place just for one person, and that is person number 2. So, in terms of person number 1, yes, the threshold for proving illegal working wasn't met, but regardless of that, he was encountered on the premises at the time of the visit by our officers. His efforts were providing a benefit to the business, and he was seemingly not receiving anything in return for that.
Thank you. Councillor Williams, please.
Thank you. It's a question actually for a legal representative. Is food considered a form of payment? The reason I ask is that this is specific. They're claiming payment, and you're saying it's not a payment, it's a benefit. Can you elaborate, please?
I'm not an employment lawyer, but the way that the report reads out, those employers, it was the report, or the Home Office report clearly suggests that that the workers or the alleged workers were receiving something in return for their efforts, and therefore it's not financial, but it's something else. It's some other benefit that they are receiving just for being there and for working or for their efforts.
Can I ask you the same question?
Yes, my understanding is that that would be considered as remuneration, yes, if it was received in return for their efforts, yes. That's maybe delving into what's going to be covered in the upcoming appeal hearing, I don't know, but in terms of remuneration, from past experience, in many cases, yes, that is considered as remuneration.
Thank you for that. Any further questions at all? No. Any questions at all? Oh, sorry, Councillor Canavan.
Just a question, if I may, to the Home Office representative. Is there any particular reason why this has taken 9 months?
Yes, my understanding is that the time delay is due to the civil penalty process taking a long time, as the owner has objected. We maintained our decision, and we are now at the situation we're in, so that's why it's taken this long.
Thank you for that. I think there's a general problem with civil proceedings, I understand, nationwide. Right, are there any further questions, members, at all? No? Mr. Herbert, did you wish to sum up at all?
I did. I'm quickly just gathering some notes on comments which have come up, so I will do my best. I think I would just first of all say we've obviously just had a bit of a discussion about the technicalities of employment law, and I think we're all agreed there's no employment law specialists here today, and this is why it was so important that the ongoing civil penalty case was allowed to determine before this, but we are where we are. I have to say I must respectfully disagree that the reason that this was brought some 9 months later is due to the civil penalty notices. These are two completely and unrelated issues. If the Home Office wished to bring a review application, it could have done so in November. There's no reason for the two to be linked in any way. Just on the point of the details saying that individual 2 confirmed that he was a worker, I think there are points to be taken in that regard. With this is very much a fixed, templated form that the Home Office have in their pack. And it is very much set up to have people who are in a high stress situation, whose English is not their first language. How long have you been working at this business? It's planting the answer in their mind that they are a worker already. A more balanced and objective approach to that would be to say, what brings you? What's the reason for you being in the premises today? A much more open-ended approach, whereas this is very much designed to funnel people into confirming that they are workers. We've touched on the fact that the meaning of a worker and employee is very significant. I've given you 2 of my takeaways as a non-employment lawyer of the 2 most important planks of that, and the degree of command and control the employer has over an employee, and remuneration being received. I do not agree that the provision of food would be seen as remuneration. But I say I am not an employment lawyer, and I wouldn't want that to, or anyone's views to have sway in that regard. But it is clearly a technical subject. I think that's covered all the points raised, so I don't have any further submissions.
Thank you for that. I've just got a query from members with regard to employment law. Councillor Canavan.
No intention to undermine anything that you've said or question anything that you've said, but I do take objection to one point. I have a master's level degree in employment law, so just please, thank you.
Russell, did you wish to sum up at all?
Yes, thank you, Chair. The Home Office does not wish to be involved in unnecessarily restricting community businesses and services such as pubs, restaurants or shops. However, there are serious concerns over the way this business was being run, as previously mentioned. There needs to be a remedy to that, which should also serve as a clear message to other businesses who are fully compliant with relevant legislation that satisfactory action has been taken. I've outlined our position that the licence holder is ultimately responsible for the illegal working at the premises, and shown our evidence from the visit of November 2024 that we believe illegal working was taking place at this premises on that occasion. As such, we have no confidence in the licence holder upholding the licensing objectives going forward. We have presented evidence to inform the committee's considerations and to draw its attention to the significant risk of the prevention of the crime and disorder objective being undermined. In line with relevant guidance, the Home Office is seeking for the subcommittee to consider revocation of premises licence. That's it.
Thank you. Right. Thank you for your attendance this morning. I will now conclude the hearing. At the end of this meeting, the subcommittee will adjourn in private with the legal advisor and clerk to deliberate. The decision will be conveyed to you in writing as explained earlier. Did you wish to just touch on the right of appeal, Andy, please?
Right of appeal is 21 days, and that starts to the Magistrates' Court, and that starts on the date on which notification of this decision is sent to the applicant in writing. Thank you very much.
Thank you. That concludes the hearing. Thank you very much for your attendance. Item 7 on the agenda this morning is the application for the Sandpiper 97 Bure Lane, Christchurch, BH234DN. For the benefit of anyone following the live stream, please note that this hearing is no longer required as the applicant has withdrawn their application. I therefore close the meeting with no further business to conduct. Thank you very much.